So the unitary patent system consists of a unitary patent supported by two regulations, one creating the unitary patent and one relating to the translation arrangements. The translation arrangements are essentially also a transition arrangement where translations are required only for a certain period of time in terms of the actual life of the unitary patent itself, not the individual, but the unitary patent procedure. And there's the Unified Patent Court. If you have a unitary patent for a number of countries, you need a court system to oversee litigation and legal proceedings, and there has to be a corresponding Unified Patent Court. And the unitary patent system entered into operation on the 1st of June last year. So the basic principles of the Unitary Patent system were driven by the requirement for a simpler and more cost-effective option for patent protection and dispute resolution across Europe. The classic European patent system or patent protection means that, for example, once your patent has entered the national phase or becomes national patents, any legal system or any legal proceedings will take place nationally and individually. So, for example, if you have a European patent which is valid in 10 countries, a revocation or opposition in one of those member states doesn't mean that it's effective in all the others. So if so it's kind of it's let's say a backup system, if you like, but it's fragmented. On the other hand, the unitary patent system is all for one for all. If you have a single revocation procedure, then the entire unitary patent is revoked. But we'll come to that. So the unitary patent is based on the European patent granted according to the EPO procedure. So there's one centralized post-grant procedure at the EPO. Currently, you get a single protection in the 18 member states. I'll show you a map of coverage a bit later on. But basically, a single request means that in a territory of 18 EU member states, the unitary patent will have effect. The unitary patent is in addition to the existing European and national patent systems, and there is only one uniform litigation system, the Unified Patent Court, and we'll look at the Unified Patent Court a little bit later on. So this is what the map looks like, and apart from the coloring in being blue, you'll see that the blue areas are not as extensive as the red areas that I showed you in the map earlier on. So far, a unitary effect is possible for those states where the Unitary Patent Court has entered into force. So for these blue countries, they're part of the unitary patent, if you like. And the idea is, of course, that all possible members of the EU, member states of the EU, will sign up to the unitary patent and the Unified Patent Court. And I'm using the term unitary patent and unified patent rather than community patent or EU patent, simply because not all of the EU member states are taking part, notably with the exception of Spain. Spain decided for many, many reasons not to participate in the unitary patent or the community patent. So it can't be called a community patent because it's not for all members of the European community. So there will, as time goes on, more and more member states will join the unitary patent and the Unified Patent Court. But at any given moment in time, not until they've all joined, there will be exceptions, there'll be absences. And it means that there'll be different generations of unitary patents with different territorial coverages in the initial years as more and more countries join in. But it means that, for example, if a particular applicant has unitary patent coverage now and other countries join later on, the patent protection will not be extended to those later joining countries. But the territorial coverage at any given instant in time is given in the European Patent Register and the Unitary Patent Register, which we'll have a look at a little bit later on. So just to try and simplify this, it's just an add-on, if you like, to the European patent procedure. So on the left-hand side in the black, the EPO procedure is filing, search, examination, grant, as we've seen before. So it's based on a European grant granted by the EPO under the European Patent Convention. The same application and examination procedure is in force, and the EPO tries to make sure that this is a high-quality product and service. It's an EPO procedure. But once that European patent has been granted, the patent holder, the patentee, can request for unitary patent effect. So this is just a request at the EPO. It can be requested within 1 month after the grant. It can offer uniform protection, simultaneous protection, currently in 18 EU member states. And there's no need for any other validations, no need for parallel national validations. And in this case, the EPO acts as a one-stop shop for all of the other subsequent transactions, for example, collecting renewal fees. So the